The very act of a divorce is still very strong. If you go to the villages, they even murder people, from what I read in the newspaper. They murder their own children because of their izzat. And in towns where they are more progressive, the feeling is that, oh well, something to talk about, what they're going to do next, and the social, we can't invite them, they just divorced, all that still goes on. I'm talking of the state of India in this particular period of time. But as time goes on, I see further problems for making this bill an ideal one, and that is, as you all know, that our caste systems have not gone. In fact, I have a feeling from the time when I was young to now, the caste system is even stronger. Don't ask me why I say that, I can't prove it, but the word caste is used for practically everything that you want to get done. Now, to add to the caste problem and the dowry problem, I have one more which has come up, and that's the last point I want to make, madam. This question of children, which is a very important factor in marriage and divorce, will we take a very different view if the world takes up to cloning. Cloning means you can have children without sex at all. Man is unnecessary. And so if you can have 100 children, somebody has to look after it. The sheep can't look after its the human beings. It is the human being that has to be looked after by somebody. But with the coming of cloning, which is going to come whether you like it or not, there are many people trying to pass laws to stop cloning. I don't think this is possible. Madam, you are a biologist yourself, and you can probably project and see what will happen when cloning becomes an easy possibility. As it is, artificial insemination is already there. It's done constantly, done with the animals, and now with many human beings, they have children easily. No one doesn't know who the father or who mothers is, just the injection tube and modern sterilization. That's all that matters. So all these things will have an effect on your divorce laws, on your marriage laws, on your social laws. So I just wanted to bring this to the Honorable Minister's attention, and because I am supposed to be a nominated member and always has the benefit of many other speakers before we can speak, because we are allowed only at the end. And with that great knowledge, I bring to his attention that we have to look into the future, and your bill must allow for changes as things go on. But many of these things which I have said in a very short way is something that will come in a very short period of time. These things have happened in a very short period of time, and therefore one has to be ready and be prepared to say that these amendments you passed only 5 years ago is totally out of date. Madam, thank you very much for listening to me.
Yes, they do office. Shri N.K. Premachandran, you are the last speaker. So please, then I would.
Thank you, madam, for giving me this opportunity to participate in the debate in respect of the divorce bill. Madam, I would like to, first of all, I would like to welcome and support this bill moved by the Honorable Law Minister. The original bill which has been introduced in the House by the then Law Minister, Madam, you may be remembering that huge protest has come from the churches as far as the original bill is concerned. The main reason for the protest from the churches was the churches who are not consulted in drafting or in making such an amendment to the personal law. So first of all, I would like to make the suggestion that whenever a personal law is going to be amended, or when a legislation is taking place in respect of a personal law, definitely the particular community and the community should be consulted. That is a must as far as our secular country is concerned. But here this bill, this amendment has been brought out. This original amendment bill, along with the official amendments by the Honorable Law Minister, it is very clear and specific. After taking into consideration of the aspirations of the particular community, especially those of the bishops and all, and after this bill is being introduced and it is being stated for discussion. So I would fully I would like to support the bill. At the same time, I would like to make my first apprehension regarding this. Madam, as far as the canon law is concerned, the basic principle is man cannot separate what the God has united. That is the canon law's basic principle. So even now the Christian community or the canon law do not accept the term divorce. But recently the churches have started the dissolution of marriages, more or less they have accepted. It is going on practice due to the reasons, due to the forcible reasons, due to the compulsory reasons. But what the thing is here, as far as this amendment bill is concerned, the confirmation from the High Court is taken away. That is a very good thing. The application for the dissolution of the marriage has to be presented before the district court, and the verdict or the decree of the district court need not be confirmed by the High Court in order to avoid the delay in the procedure. But what is the binding effect of this decree when it is passed by a civil court which is having jurisdiction? The dispute or the conflict still remains, madam, because a decree passed by the civil court is not binding or is not acceptable to the church, or it is not acceptable to the courts of the church. So if that be the case, and also there is also courts of the church, there is dissolution of marriages in the church's courts also. A decision of dissolution of a marriage by the church court is not acceptable to the civil court also. So even though the honorable minister and the government is taking very earnest efforts to make an amendment so that the delay in the procedure can be shortened, but still the thing of the delay remains. Two parallel proceedings are still there. So what my suggestion is, this particular thing, that is the civil court decree is there and the church's court decision is there. If both are conflicting, then what is the outcome of it? So my suggestion is to have a consultation among the churches, to have a solution. Government has to think about it also. After consulting the churches, a decision, a solution has to come out about this thing is concerned. That is my first point. And regarding the second point is regarding the adoption as far as the Christian law is concerned. Madam, still now there is no law for adoption as far as the Christians are concerned. It is a long pending demand of the churches that a law for the adoption has to be there for the Christians are concerned. That has not been fulfilled so far. This is also a long pending demand. And regarding the third point, which I would like to seek the response from the Honorable Minister regarding the Christian Marriage Act 1872. There was a proposal for drastic amendment to this Christian Marriage Act, because it is a solemnized act. As far as Christian law is concerned, marriage is a solemnized act. And after the solemnization of the marriage, even the ceremonies are different as for different sects. I think that according to my limited knowledge, there are 300 sects and 300 different varieties of ceremonials of marriage. Whether is there any proposal is pending before the government, or it is under consideration for having a uniformity among the Christian community. There is a proposal. Whether there was a proposal for having the ceremonies to be a unity among the ceremonies as well as the marriage is concerned. As far as the Christian marriage is concerned, I am not speaking about the uniform civil code. But as far as the Christian marriage is concerned, there was a proposal, there was a move. What happened to that Special Marriage Act also? Sorry, Christian Marriage Act of 1872. And also regarding these, yes madam, I am concluding, regarding these amendments also, this amendment to section 10 and the new amendments, official amendments to clause 4A, this gender inequality which was there for so many decades, that has been removed. And also this, it is now the new section 10(1), as far as the official amendment, it is very clear, unambiguous, and also a new provision, that is wife is also giving much more importance, or women is also giving much more importance as for getting a dissolution of the marriage if he has been guilty of rape and bestiality and sodomy also. And considering all these aspects, I would like to, once again, I would like to suggest that when a reform as far as with this personal law is concerned, the churches or the concerned community should be consulted, and an amicable solution has to be found. With these words, once again, I support this.
Thank you. I think different ceremonies shows the variety the country has. Ceremony has got nothing to do with law. These are the customs. 16 or 14% of our law is customary law. Yes, Mr. Minister, you know it better.
Madam, we've all had the privilege of listening to the views of a large number of members. You're right, you made a point in response to what the Honourable Member just said. With regard to customs, the Honourable Member in fact made two very valid points. The first was that always the community must be consulted when you amend personal laws. Secondly, even within the parameters of personal laws, there have always to be a distinction maintained between the rituals and the customs which are personal to the religiosity of the community. The second aspect is in relation to various rights which emanate from either marriages or divorces. I do not think there is any need by law at this stage or at any stage to say that everybody will follow the same custom, because customs in different communities will always be different, and therefore that's an area which the communities, as they evolve, they are capable of taking care of themselves. We have really to be concerned more as far as the arena of rights is concerned. Madam, there have been several very important suggestions which have been made. At the very outset, let me suggest this, that even before the initial amendment was introduced in the Honourable House, a conference of the leading members of the community had been organized by the Department of Legislation. Their views had been taken. And not only the views had been taken, it was also a constitutional duty of Parliament to legislate in relation to two areas, particularly because those areas had been struck down by courts. We could not afford to leave a vacuum as far as law was concerned. We have to remove the non-discriminatory law. We have to bring in a non-discriminatory law and remove the discriminatory law which the courts had struck down. After we introduced, some more consultations were held. Initially there was many views which were there. The Christian women very strongly argued in favor of a particular viewpoint, and I must be also very grateful both to the Christian women organizations and also to the church authorities, who subsequently all converged to a single point of opinion and supported these amendments before the Standing Committee. The Standing Committee also has returned a finding which is unanimous, and except one area, the Standing Committee accepted all the suggestions and we have vetoed it. And that one area is again the last one which the Honourable Member mentioned. What about courts created by religious organizations? I'm afraid this is something we cannot agree to. I'll just quote from what the Law Commission had said in this area. The Law Commission's 15th report, which was the first report on the Indian Divorce Act, had said, it is the courts constituted under the law of this country that have the exclusive authority to determine disputes relating to civil rights, and there can be no surrender or abdication of that authority. You cannot have parallel proceedings going on before courts which are informally constituted by people. The only institution of courts which law recognizes is courts created under our constitution and under our law. And therefore this suggestion that there must be a parallel jurisdiction did not find favor either with the Standing Committee or with the government, and that's the only suggestion of the community, or a section of the community I may say, which we did not accept. I must say that this is not the only changes. Whenever we speak of legislation, we speak in terms of having comprehensive laws, but there are several aspects of laws which require a reform. And merely because some reforms have not started in some areas is no reason why we must hold up reforms in other areas where a situation has come where reforms are now easily possible. In fact, a study of this law itself will give us an illustration of how consensus within the community itself determines itself. We've had in the last 50 years several efforts made to reform this law. As I mentioned, this 1869 law is based on the English Act of 1857. England repealed that act in 1923. And in the second part of the 20th century, we had repeated resistance to the amendment of this act in India. But then ultimately the community all got together and said we must change and improve upon this act. A very important point was made by Mr. Saifullah. He said, what is the advantage that women have unless you amend some corresponding provisions of the criminal law? And the chair commented that we were unable to comprehend what the relationship between the two was. This is a civil law, a personal law. In this personal law, there were discriminatory grounds given to a man and a woman. There were several other discriminatory provisions. There was also an obsolete provision of going to the High Court. All those aberrations have been corrected. This has nothing to do with the criminal law liability which a husband may incur in the event of his committing bigamy or polygamy. The criminal law provision which Mr. Saifullah was referring to was, under our criminal law, if somebody commits bigamy or polygamy, the right to institute the criminal proceeding vests only with the aggrieved wife. Now, whether there is a need to change this or no need to change this is an issue which is entirely separate, which can be independently discussed in this Honorable House. But that is no ground till we amend that law and give to strangers also the power to initiate prosecutions in the event of bigamy or polygamy. That is no ground till that is done. We stop the process of reforming a law where reforms in fact have been long overdue. There was one suggestion which was made by Mrs. Dubey, when she particularly said that why are you when you are removing the 1/5 ceiling, why are you keeping it to 1/3? Why don't you leave it to the courts to determine what the quantum of maintenance should be? I may only correct that this is precisely what we have done. The original law said 1/5. We have removed that 1/5, the maximum that the wife could get. She could get less than 1/5. We have removed that condition, and today it is entirely within the realm of judicial discretion as to what is the quantum. We have not kept any limitation of 1/5 or 1/3 as far as these amendments are concerned. There are one or two minor changes which exist from other personal laws. For instance, on the dissolution of marriage by consent, as was Premdasan mentioned in the end, that the Catholic law says that those whom God has united, law cannot separate. Well, that's the essence behind the respect of marriages which the Christians have for their marriage, the reverence that they have for their marriage. Now, it was therefore the community which suggested to us that do not use the word divorce at any stage in the text of the Act, and therefore we decided to use the word dissolution, keeping that sentiment in mind. But there were certain other changes that they wanted. For instance, in the Special Marriage Act and in the Hindu Marriage Act, the period of separation for the purposes of consent divorce is 1 year. But here the entire community expressed the view that we want a slightly larger period. So for the couple to really determine on account of their entire tradition and relationship of religion and separation of this kind. And therefore, with the consent of the community, we fixed the period of 2 years. Since this was a point on which there were some strong views the community had, we decided to accept and honor those views. There can be conflicting views we have in this house, but this was, as I said, since it's a personal law reform, we did respect the views of the community itself. There are other one or two minor changes which we have where there is a distinction between the Special Marriage Act and this law. Mr. Gowda asked a question, raised two very valid questions. One was in relation to having a neutral personal law which defies religion, where people of any religion can choose to get married under that law. But yes, we do have the Special Marriage Act specifically for that period. It's a law, you can belong to any religious denomination, you can get married under that act, you can get divorced under that act, you will incur liabilities under that act. Even today, if Christians chose to marry under the Special Marriage Act, they were welcome to do so. Any person belonging to any religious, in fact, trans-religious marriages are also held under that act. It's a law which goes beyond this.
What I emphasize was, they will be married in different laws, under different laws. My submission is, or my say is, whatever laws they have married, if they want a divorce, under those circumstances, a law is to be made, that law has to be given powers to overriding all the personal laws, and a relief is to be given under that law.
Well, I wish we could in the terms of national consensus, parliamentary consensus, reach a situation of that kind, but we have not done so. And therefore, I think till the time we do so, it would be always advisable that whatever provisions of personal laws are which otherwise are discriminatory or go against human dignity, if we with the concurrence and the consent and participation of the communities try to correct those aberrations, that's the process which we currently are involved in. There are also questions which you raised, which I completely agree with, that we are trying to cut short procedures, we are trying to fix time limits, but will that ever happen in courts? Well, let me straight away start with a confession, that as far as the government is concerned, the government can actually try at the state level or the central level create infrastructures. The parliament will amend laws, give a mandate and the spirit behind the law. Well, this is how we want the law to be operated. These are the time limits we have. But ultimately, this is one area where the management and administration of those laws particularly relating to the administration of justice, is entirely within the realm of judges and lawyers. And therefore, this sense of expediency, which we are trying to indicate through these legislations, must also be simultaneously reflected in the implementation and administration of these laws by our judges and lawyers. Otherwise, you are right, we may keep amending the laws, we may keep fixing, indicating the periods under which the public policy requires expedition, and we may still be faced with a situation, as the example of the Bangalore case you gave, that even the orders itself are not being implemented, that we may not be able to make a substantial headway. Dr. Ramanna made some very interesting points, and I think some of these points would require the legislature at a suitable date to actually consider the consequences of this. You mentioned that number of divorces are going up. In India they are not so high, but in the Western societies they have increased. But one factor which most civilized countries have kept in mind, that even when divorces have increased, they have all been trying to make divorce a very costly proposition. When you divorce your wife, it is not very easy to walk out of marriage without paying for it. And therefore, not only you pay for it, you pay effectively, you pay urgently, so that this also has a social constraint people keep in mind. You mentioned that perhaps people may start a situation where they may bypass the law, so as to bypass the law, bypass the lawyers, bypass the courts. Well, such situations have arisen, and some countries, when we are not confronted with this situation in a big way. But if at all, unfortunately, one day we were, law would have to take notice.
We are not confronted with it in the middle class, but in the lower class, they don't care for you.
Well, I am sure, just as you have a chapter on alimony, you may have to provide some suitable compensations as far as children are concerned, the other spouses to the marriage are concerned in a situation of this kind. Already there are world jurisdictions which have started speaking in terms, which have started recognizing palimony. And therefore, the illustrations which you had in mind are not very difficult to envisage. We may try and avoid the law, but I think law also has the ability in these kind of situations to catch up with. But you are right, when technological developments take place, then who the spouses are, what the liabilities are. In the case of artificial insemination, who the father would be. In the case of human cloning, what the parental rights would be. At some stage, law will have to catch up with technology when those issues do arise. There is a link between the two. I am afraid today we have no such situation. We recognize that, but I am glad that you have, in fact, cautioned us about what could be a possible scenario in the decades to come. So I am extremely grateful to the honourable members who have almost unanimously supported this particular legislation. I think this is one law where reform was long overdue, and I am glad finally it has come. I propose to this honourable House to kindly adopt this law.
What about the law of adoption?
Well, as far as, you see, there are several other aspects are concerned. I must tell you, when the conference was called, there were several aspects of the Christian laws which were taken into consideration. In fact, one of the suggestions was, and a draft law also was prepared by us, which would take marriage and divorce laws and then total them so that the entire personal law of Christians becomes one. There was no consensus on it.
Because it is marriage and divorce together.
There was no consensus on it. And therefore, please permit us to move at the pace with which there is a consensus developing as far as the community is concerned. We have brought those provisions with which there is a very large consensus. In fact, I may only inform, there is yet another provision on which there is a consensus. As many as 23 Christian members of parliament have written to me that they have still a law compared to other communities where they are discriminated against in the law of succession. And we are seriously looking at that. So allow us to do it in stages whereby we can carry the consensus of the community rather than bring in those provisions where there is still an absence of consensus. Therefore, these were reforms which are long overdue. I am sure there would be in years to come. No law can be static. And as and when our consultations with the community and their aspirations also rise, I am sure other reforms would also take place.
I think after such a elaborate and specific reply of the minister, we can take the question that the Indian Divorce Amendment Bill 2000 be taken into consideration. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The motion is adopted. Now we shall take up clause by clause consideration of the bill. Clause 2 stands part of the bill. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 2 is adopted. Clause 3. Now there is an amendment to clause 3.
Sir, I move the amendment.
Amendment moved. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The amendment is adopted. I shall now put clause 3 as amended to vote. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 3 as amended is adopted. There is one amendment for insertion of new clause 3A, number 4 by Sri Arun Jaitley.
Sir, I move the amendment to clause 3, capital A.
Amendment moved. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The amendment is adopted. I shall now put clause 3A to vote. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The clause 3A is adopted. Clause 4 stands part of the bill. There is one amendment.
Sir, I move the amendment to clause 4.
Number 5. Amendment moved. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The amendment is adopted. I shall now put clause 4 as amended to vote. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 4 as amended is adopted. There is one amendment for insertion of new clause 4A, number 6.
Sir, I move the amendment.
Amendment moved. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The amendment is adopted. I shall now put clause 4A to vote. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The clause 4A is adopted. Clauses 5 to 16 stand part of the bill. Those in favor will please say aye. Aye. I think the ayes have it. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clauses 5 to 16 are adopted. Clause 17 stands part of the bill. There is one amendment, number 7 by the Minister.
Sir, I move the amendment.
Amendment moved. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The amendment is adopted. I shall now put clause 17 as amended to vote. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 17 as amended is adopted. Clause 18 stands part of the bill. There are two amendments, numbers 8 and 9. Minister.
Sir, I move the amendments number 8 and 9.
Amendments moved. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The amendments are adopted. I shall now put clause 18 as amended to vote. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 18 as amended is adopted. Clause 19 stands part of the bill. There is one amendment, number 10.
Sir, I move the amendment number 10.
Amendment moved. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it, the amendment is adopted. I shall now put clause 19 as amended to vote. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 19 as amended is adopted. Clause 20 stands part of the bill. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 20 is adopted. There is one amendment for insertion of new clause 20A, number 11 by the Minister.
So I move the amendment number 11.
Amendment moved. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The amendment is adopted. I shall now put clause 20A to vote. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The clause 20A is adopted. Clauses 21 to 29 stand part of the bill. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clauses 21 to 29 are adopted. No, that we are specific amendments we are carrying along with the clauses. Clause 1 stands part of the bill. There is one amendment, number 2, by Sri Arun Jaitley.
Sir, I move the amendment number 2.
Amendment moved. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The amendment is adopted. I shall now put clause 1 as amended to vote. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 1 as amended is adopted. The enacting formula stands part of the bill. There is one amendment, number 1, by Sri Arun Jaitley.
Sir, I move the amendment number 1.
Amendment moved. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The amendment is adopted. I shall now put the enacting formula as amended to vote. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The enacting formula as amended is adopted. The title stands part of the bill. Those in favor will please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The title is adopted. Now the Minister to move that the bill as amended.
Sir, the bill as amended be passed.
Motion moved that the bill as amended be passed. The question is that the bill as amended be passed. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The bill as amended is passed. Now we will take up the consideration. The Government of Union Territories and the Government of National Capital Territory of Delhi Amendment Bill 2001. Sri Vidyasagar. Only 2 names are there.
Sir, I beg to move that the bill further to amend the Government of Union Territories Act of 1963 and the Government of National Capital Territory of Delhi 91 as passed by the Lok Sabha be taken into consideration, and also beg that the bill be passed, sir. So it's a very simple bill, sir. The 2 union territories, that the National Capital Territory of the Delhi and Pondicherry, both of the union territories, they have separate legislatures and they have a consolidated fund also. But both the legislatures, they do not have power to borrow from the market upon the consolidated fund of the respective union territories. Secondly, sir, they do not have any public provisions are being provided here to have a public account. They do not have any public account, and that is the only to for the financial discipline and to maintain the accounts, sir. They do not have a public account. The provisions are made by virtue of this amendment to have a separate public account in this. Sir, the bill seeks to amend the Government of Union Territories Act of 1963 in relation to the Pondicherry and the Government of National Capital Territory of Delhi Act 1991. In relation to the National Capital Territory of Delhi, to provide that the two union territories having legislative assemblies may be given the power and authority to borrow from market and to give guarantees upon the security of the consolidated fund of the union territory concerned. The reason is that the said two union territories have their own consolidated funds, but they do not have the power to borrow from the market. The lieutenant governors of these two union territories would also be allowed to exercise the powers of the Government of India in this regard. In addition, provisions are being made for having their separate public accounts as well as their own cash balances with the Reserve Bank of India. This revised arrangement is envisaged to enable the Reserve Bank of India to monitor the ways and means position of these two union territories on the day-to-day basis and bring them within the normal discipline relating to the limitations and regulations of overdrafts already applicable in respect of the state governments. This will also enable the two union territories to operate their finances on their own in real terms and encourage them to observe strict financial discipline. With this word, sir, I commend this bill to this August House for the approval.
So the motion is moved. I have two names before me. Each.
With this word, sir, I commend this bill to this August House for the approval.
So the motion is moved. I have two names before me. Each speaker has 2 minutes each. And I want to make this very clear at the very outset that we do not want an extended debate on the situation in Tamil Nadu on this. So the first speaker is Sri Viduthalai Virumbi. You have 2 minutes for you.
Within 2 minutes I'll finish. The Vice Chairman, sir, the bill has been brought before us for consideration. It actually an enabling provision has been added in this. Sir, after the bill is passed, the union territories will have the powers to borrow. That is the main provision of this bill. Sir, regarding this, I want to tell only 2 or 3 sentences. In 1996, the Estimate Committee has given a report in which it inter alia said the elected representatives of the union territories must be given more powers to see that it is really a democratic government, a people's government. Sir, that observation was made in the Estimate Committee in 1996. I hope that this is also a consequences of that report. Sir, now, after this power is given, only borrowing power is not going to make any difference, I hope. In the sense it is incomprehensive one, because, sir, the Council of Ministers in the states and the Council of Ministers in union territories, what is the difference means? The executive power, real executive power in the union territories lies with the Lieutenant Governor, not with the Council of Ministers. But in the state governments, the executive power lies with the Council of Ministers. When the advice, the governor acts according to the advice, except the appointment and the dismissal of government. Therefore, but here, suppose in one particular area, a decision taken by the Council of Ministers contradicts with the decision taken by the Lieutenant Governor, means the opinion of the Lieutenant Governor will prevail over the decision taken by the Council of Ministers, thereby the spirit of the democracy dies down there. Therefore, I request the Honorable Minister through Chair, sir, when you bring this bill, we welcome it. If you want to welcome it wholeheartedly, means it's not enough. I want to see that what is the powers enjoyed by the Council of Ministers in other states should be enjoyed by the Council of Ministers. That is the real democracy. Therefore, in such a way, the other changes, what is recorded in the Constitution has to be made as early as possible. Then only the power goes, sir, because our Constitution, British Constitution and our Constitution is different. British Constitution is unwritten one, that powers actually gives from the Crown to Lords, from Lords to common people, that is British Constitution. Here, the 1947, August 15, the sovereign lies with the people. People has given the power to the representatives. But the main concept is being actually blacked out because of this situation. Therefore, I request the Honorable Minister to Vice Chairman, please see that the real power should rest with the Council of Ministers, not with an individual appointed welfare care. With these words, I support this bill, but I hope it will be furthered in such a way that the aspiration of the Pondicherry people are fulfilled. With these words, I conclude. Thank you very much, sir.
Now, Shri P.G. Narayanan.
Mr. Chairman, this bill seeks to confer authority on union territories of Delhi and Pondicherry to borrow upon the security of the consolidated fund and also to provide separate public accounts. This is a welcome step. For the past several years, there has been persistent demand that Pondicherry should be conferred a statehood. As far as our party is concerned, we had all along supported this demand. Our leader also already made it clear that Pondicherry should be conferred statehood. I hope that this amendment is one step in that direction. But the Government of India is not at all concerned about the democratic aspirations of the people of Union territories. It was after long struggle that Delhi got the status of national capital territory with legislative powers, legislative assembly. More and more powers would be vested in the Government of Union territories so that they could really serve the people in full. The Government of India has to take care of the Union territories which is not able to implement the welfare measures because of lack of adequate resources. Another aspect I would like to stress that Government of India should not create obstacles in the way of working of the Government of Union territories to make the Union territories self-sufficient, self-reliant and self-ruled. Panchayat Raj system should be implemented effectively in Union territories. Sir, I urge upon the government to consider seriously the demand that Pondicherry should be conferred statehood as soon as possible. With these words, I support this bill.
I think we had actually two speakers, but subsequently Dr. A.R. Kidwai of.
I would like to take this opportunity to move that both the territories, the Union Territory of Pondicherry as well as Delhi, should be declared as states. Without the status of full-fledged states, they cannot function efficiently and properly. There is duplication of administration, there is conflict of ideas, and there are administrative delays and difficulties. In view of this, while I support the bill, I suggest that as soon as possible, both the states territories should be given the full statehood. Thank you.
I also demand this. Sir, as my colleague has stated, I too demand that statehood should be conferred on the state of Delhi and Pondicherry. Thank you, sir.
Now, Mr. Minister.
Sir, I am thankful to the honourable members who had supported this bill, sir. But there was only one important demand was made about the sanctioning of the separate statehood for the Delhi and as well as the Pondicherry, sir. Sir, the statehood, so far the Delhi is concerned, sir, the views of the government of National Capital Territory of Delhi on the proposal of the grant of full statehood that have been sought, sir. Further action will be taken after taking their views into consideration, sir. So far as the Pondicherry is concerned, the Pondicherry government, they have already passed a resolution in an assembly. The resolution for grant of statehood with a special status, sir, this was passed by the Legislative Assembly of the Pondicherry. The provision for grant of special state of Pondicherry has not been agreed with the Planning Commission. The government of Pondicherry was asked to send special report on this special status which was sought by the Pondicherry Legislative Assembly, sir. After taking their views, a decision would be taken, sir. I therefore request that the bill be passed, sir.
Now, the Minister has replied. The question is that the Government of Union Territories and Government of National Capital Territory of Delhi Amendment Bill 2001 as passed by the Lok Sabha be taken into consideration. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The motion is adopted. We shall now take up clause by clause consideration of the bill. Clauses 2 to 9 stand part of the bill. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clauses 2 to 9 are adopted. Clause 1, the enacting formula and the title stands part of the bill. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 1, the enacting formula and the title are adopted. Mr. Vidyasagar Rao, to move that the bill be passed.
I beg that the bill be passed.
Motion moved that the bill be passed. The question is that the bill be passed. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The bill is passed. I think now we are going to take up the Energy Conservation Bill 2000. Mr. Prabhu, to move that the bill to provide efficient use of energy and its conservation for matters connected therewith or incidental thereto as passed by the Lok Sabha be taken into consideration. You please move.
Sir, you will recall that in this very house, only about a few weeks ago, there was a question which Honorable Member of Parliament, my colleague in the House, had raised about the need for resorting to demand-side management to meet our growing energy requirement. It was a general prevailing mood of the House that while we need to enhance our capacity by creating more and more greenfield power projects in the country, we should not overlook the importance of energy conservation. Because while we generate more, we need to invest more. We also use our natural resources to generate more energy. But at the same time, if energy generated is not properly utilized, then we are wasting a very precious resource, and also we are not optimizing the investment that has gone into that. With that view in mind, the government has come out with a new legislative proposal before the House, which seeks to create a legal framework for conservation of energy. This new legislation seeks to provide a framework in which agriculture, manufacturing, household users as well as services would be required to use energy in the most efficient manner. The bulk users of energy will be designated as designated users of the energy, and then they will be obliged to resort to energy audit, and the energy audit will bring out the various ways by which energy could be conserved, and those measures will have to be implemented by the respective designated user. Sir, this is intended to bring about a potential which is like it is there in the energy conservation sector, which is as high as maybe up to 40%, and that can really be unleashed through the legislative measures that are sought to be introduced before the Parliament. Sir, there have been a number of measures which we could take under these particular provisions of law. First of all, agriculture pumps, which are very critical and they use a lot of energy, but because in many states agriculture is not charged, and the use of electricity for agriculture is not charged, as well as the agriculture pumps are not necessarily resorting to certain ISO standards, the energy conservation potential is also there, which is not yet harnessed. So manufacturing sector like fertilizer, cement, steel, petrochemicals, and all this energy guzzling industry could also save energy substantially. Even the households, and now there is a growing tendency of using various white goods, maybe it's washing machine or refrigerator or a heater or a microwave oven. All these white goods have a potential to save and conserve energy, and therefore the bill also seeks to introduce the first measure, a labeling provision, whereby a customer, when he is buying a particular white good, is making an informed choice to find out whether this particular equipment that he is buying is resorting to or conforming to the various requirements of energy conservation legislation, as well as whether it is going to be energy efficient machine. Sir, even on households, commercial buildings, they are saying that if energy conservation measures are introduced, there is a potential to save energy as high as 20-25%. So therefore, sir, this bill was introduced in Lok Sabha sometime back. It was referred to the Standing Committee of Parliament. The Standing Committee made several recommendations, and I am very happy to say that I have accepted all the recommendations of the Standing Committee without exception. All the recommendations of the Standing Committee have been accepted, and in fact some of those recommendations are now incorporated into official amendments. So therefore it is going to take some time before the formal passage of the bill takes place, because we are going to discuss probably so many official amendments that are moved. Sir, there could be one of the apprehensions that could be expressed by the members, that when we are introducing another legislation, and to conform to that legislation we'll need an army of officers and the bureaucracy, will it increase the burden on the compliant to resort to maybe filing returns, and there could it also resort to Inspector Raj? So therefore I would like to announce that while framing rules, I already decided that we'll introduce a concept of self-regulatory organizations. In fact, to actually make it happen, even before the bill is passed, I already consulted all the trade organizations, manufacturing organizations. I am in the process of talking to consumer organizations next week. I am going to meet all the farmers organizations for the week following, and then we will be actually coming out with a mechanism which will be like a self-regulatory apparatus, so that the conforming to this bill will not require any necessary inspection by the inspectors, and which will not increase the burden on already overburdened compliant of the modern society. So therefore, sir, this bill is before the House. Bill has already been passed by the Honorable Lok Sabha, and as I said, in this bill which is passed by the Lok Sabha, we have incorporated all the recommendations of the Standing Committee of Parliament, and therefore I am very sure that this bill also will be passed by this august House unanimously. Thank you, sir.
So the motion has been moved, but what I propose before this House that we are to start our discussion on internal and external security threat from 4 o'clock. Some 3 minutes are left. So let us have the discussion subsequently, but we will start the short duration discussion now. Okay.
And that is with regard to this bill, I take this occasion that it's as passed by the Lok Sabha. Now there are several bills that we have had this session, we'll have more. I would respectfully suggest to all the honorable ministers and to the Minister of Parliamentary Affairs that it would be extremely convenient to have the statement of objects and reasons also for the bill when it was introduced in the Lok Sabha, so that we may be in a position, better position to appreciate and debate various bills that are introduced here for being passed. And if that would be possible, so that when we get these bills as passed by the Lok Sabha, either we could have appended to it the statement of objects and reasons which went into the Lok Sabha bill, or we could have the entire Lok Sabha bill once again along with the statement of objects and reasons. It would only mean a few more, because that would give us the thrust and the purpose of each bill, which we do not have.
But Mr. Nariman, I will just explain the position. That when a bill is introduced in the Lok Sabha, it is simultaneously circulated also to the members of the Rajya Sabha in that form only, which includes the objectives of the bill. Oh. So demand you are making, already it is part of the parliamentary practice here.
Oh, I see, I see.
What we have,
Yeah,
when the bill, just 1 minute if you take your.
yeah.
Whenever a bill is introduced in either of the house,
Yeah.
the same copy is being circulated to all the members
Oh.
of both the houses. And same thing is also bulletinized in part 2 of the bulletins of Lok Sabha and Rajya Sabha, so that the members can consult the bulletins and find out on which day which bill was introduced, and they can get it from their own copy.
No, it's
No,
okay.
not at
It's
all. It's
okay.
a good, interesting thing.
So I think we will start the short duration discussion. Shri Pranab Mukherjee to initiate the discussion.
I hope Home Minister is coming.
He will be coming, I am given to understand that he is attending the consultative committee meeting on Home Affairs. So he will be coming in a couple of minutes.
Thank you, Mr. Vice Chairman, sir, for giving me this opportunity to raise a discussion under Rule 176 on the security scenario in the light of the terrorists and other internal and external security threats and the remedial measures taken by the government in this regard. Mr. Vice Chairman, sir,